Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome everyone to another exciting episode of Estates Made Simple. Gord, lovely to see you and chat with you today as always. And today we wanted to talk about personal directives. So personal directives are part of a comprehensive estate planning solutions. Most often clients in Alberta have to execute at least 3 documents when they're doing their estate planning documents. Their will, which governs what happens when they pass away. Their power of attorney for property, which deals with financial matters if they become incapacitated. And then their personal directive, which deals with healthcare matters if they are unable to make those decisions on their own. So that's what we really wanted to touch on today. Considerations if you are acting under a loved one's personal directive. The name that you would call yourself is the agent under the personal directive. And what considerations do you have to take when you're acting in this role? So I thought I'd jump in, Gordon, and ask you, what is the first factor to consider in the role as an agent?
Yeah, thanks. And always to your opening comments, always helpful and enjoyable to have good conversations about this stuff as we record for our audience. Glad everybody is here listening in. What's interesting, there is some interaction, right? And I guess the backdrop of where people may see these interact, as you say, we often talk about the financial implications or people who are in that role managing property, typically in an estate administration situation. It's often the person under who might be the executor would also maybe be the person who's appointed under a power of attorney. So while it's not specifically relating to the estates, it's obviously there are things that are relevant to the estate in terms of the decisions that need to be made. And one of the first considerations to give an answer to your question would be the person under the agent under the personal directive may have to deal with the attorney under the power of attorney. That a lot of people, as a bit of a digression, they see the word attorney, and having listened to U.S. cable shows or watched U.S. cable shows, they say, oh, that means a lawyer. No, attorney is a person appointed under a power of attorney to make financial decisions. In contrast, as you outlined, the personal directive is non-financial decision making. So anything that doesn't deal with money, it could be the same person appointed in both those documents, but it could be different, right? So if you're under the personal directive, you might have to work with the person who's managing the finances or vice versa to be able to make decisions. Many healthcare decisions are covered by virtue of the services provided by Alberta Health Services. And with our more comprehensive healthcare system in Canada, it's not a user pay system. Therefore, we're in a situation where there's not always a financial implication, but some things may have an implication. For example, where you're going to live. The personal directive is the person who decides what social activities you undertake, who do you associate with, who has visitation, and obviously part of that is where you're going to live. So if we're looking at the natural progression that we see in families, maybe with your parents, or that you're experiencing now, would be that at some point you can't live in your home independently and you've got to move into some other either assisted living facility or a facility that has more care commensurate with your needs. So the choice about where you're going to put your loved one, the person for whom you're making decisions, there can be a wide variance on costs. And so you're the one that can decide, but it'd be the person under the power of attorney that is going to be paying the bills. And the admin office of that care facility is going to say, who's the power of attorney? We want to know who's going to pay the monthly fee and have access to the bank account to be able to pay that. Obviously, if you're putting your documents together, you want to be mindful of, if they're different people, can they work together? But it's not uncommon to say somebody who's good on the finances may end up being appointed under the power of attorney in the will, like they'd be the named executor because that's their strength, but they're not so good in the healthcare system. Maybe somebody with a nursing background or a medical background would be a better choice for the personal directive versus the family member, the child who's a chartered accountant or a financial planner would be really good on the financial side of things. So it's often different because it's a different type of decision making, different set of skills. So just that ability to work and interact so that appropriate decisions can be made. And it's interesting to examine the document itself under the personal directive to say, what does it say about that? Because we often have a clause that says if the person under the personal directive says this is in the best interest of the person, then that decision governs. Because there could be a conflict. Whereas the person under the power of attorney, that nursing home is way too expensive. We should get a cheaper option. So the idea is the person under the personal directive has to make decisions that are in the best interest, but there's obviously certain decisions have a financial component and definitely need to make sure that people are on the same page while you're making decisions, for sure. Consideration of what's important regarding the role of an agent under a personal directive.
Further to your comment, I do really like the situations where there's a different person acting under the personal directive, as well as a different person acting under the power of attorney. For that reason, that they may have different objectives. The person under the power of attorney may also be a beneficiary under the will, so maybe they want to reduce expenses as much as possible to increase their potential inheritance. So it's nice to have a balance there. But I would say another consideration would be for the agent to really understand what they would want under certain situations, how they would feel about decisions being made on their behalf. And I think this particularly comes into importance in end-of-life measures. Some individuals, based on religious beliefs, don't want certain end-of-life measures to take place to extend their life, thinking of blood transfusions or resuscitations, things like that. And so it's really important for the agent to know that belief system. And if they don't know the belief system, or if there really isn't a desire, then the agent really needs to look at the best interest of the person. So there's a hierarchy of what to consider when making those personal decisions.
Yeah. And I think, that's really the critical part, isn't it? Just getting people appointed who would understand what your wishes are. And what I find in this scenario is that you really need to pick people who can distinguish and differentiate their opinion from what you would have wanted.
Yes.
Right? So I think what's really important is that you pick people who, in fact, will carry out your wishes versus just applying their own decision making. Because we may have certain opinions about this is the care I would like to receive, or this is how I would make the decision if it was me, but that's not the criteria. The criteria is going to be, what would this person have wanted? And you might be a person who says, I want every conceivable medical procedure to be undertaken if I ever get to this point to sustain my life for as long as I can. What if the person says, no heroic measures? That's different than what you think is the right decision, but you have to be able to put yourself in that person's shoes to say, I'm carrying out their values, wishes, and beliefs. And being able to understand that. So that, I think, is a good criteria in terms of who to appoint. But if you're finding yourself in that role, that's really your job, right? Is not to execute your own opinion. It's your judgment, understanding what their values and wishes are, which is why I think in the personal directive, it's important to lay that out, at least at a high level, right? Or at least have conversations with these people to say, this is what I would want in such circumstances. I think those are important conversations so that the person who's appointed to make those decisions in that official capacity has something to be guided by.
Yeah. And what are your thoughts on the number of agents an individual should appoint? 1 versus 2, or perhaps 3? And what is your typical recommendation to your clients?
You know, what's interesting on the personal directive is it does differ. My experience is it does differ from decisions regarding the will and the power of attorney. I probably have a stronger opinion, or will start with the assumption when dealing with one's property, that there's the efficiency of and benefit of a committee of one to be able to carry that out. Now, it depends a little bit on the complexity of the estate. The more complex, maybe there's a benefit of having more than one. But of course, more than one, you get into a problem of what if there's not consensus about what the answer to the question is that's being considered. While an efficiency makes sense in the context of managing property, I think it's a different consideration when you're managing your person, right? So this is about those medical decisions, end of life decisions. And what I see happening is that it's really difficult if we're looking at parents doing it and thinking about their adult children stepping into this role, but I don't want to exclude this person.
Yeah.
And if you could imagine if there's a disagreement about end of life and one child had the authority and exercised that, ignoring the opinion of a sibling, for example, that's going to create some friction, right? So I find there's a tendency to say, I'm going to appoint all my kids. If that's the starting point, which sort of makes sense, going, my kids are going to have to figure this out, right? I'm just going to make them work together. Number one, be careful if you are creating a huge mess which will end up having lawyers retained to solve those problems, or applications to the court, because you've put together people who simply cannot work together. So it starts with assessing your kids. And while ideally you would want the whole family to be in agreement regarding a decision, we have to recognize that there may not be unanimity. And so I think the impulse is I want them to agree on what happens to me. And that's not something they should be fighting about. But you got to look at the dynamics. If they simply don't get along, it would be foolish to name people just because they're your kids if you've set up a decision-making structure that's unworkable, right? Because then we know it's just going to end up in litigation, and then the only people that benefit are the lawyers, because it ends up going to court and it's very stressful, it's emotionally trying. So from that perspective, I think I see more often, and it makes sense, and from a recommendation of saying we want inclusion, because we don't necessarily want one person making decisions without the input of the others. But if you're going to have more than one, then oftentimes I'm having conversations with people about, okay, let's put in a dispute resolution clause. If there's a disagreement, what's the mechanism in place to be able to do it? Conceivably, you could put in a mediation provision, or you could say it's 2 out of 3, we'll decide. Right. So if you set up the rules, that helps the decision making, versus if you say nothing, it has to be unanimous. And that maybe leads to no decision being made about yourself when you can't make that decision. And that's not what you want either. That's not in your best interest with regard to that. But yeah, I think we got to look at the efficiency, though. Who's going to best carry out those wishes? Who's going to be best suited in this role? If you get the person who is great on the finances, but they fall apart in the corridors of the hospital because they hate hospitals or nursing homes, that may not be the best choice. Maybe there's a family member that has a medical background that would be a better choice because they're comfortable in that role. They get the language, they understand the issues in terms of what are the possible procedures if we have to make a decision about a surgery, or what about this course of treatment? That can have complexity to it, right? Those aren't always simple issues. So I would say consider your nearest next of kin. Typically, it's the children being appointed for the parents, but you want to make sure that they can work together, have a good mechanism in place, and definitely have lots of conversations with them about your wishes so that hopefully that's what they're carrying out versus their own issue.
And I think on the flip side of that too, if you appoint one person who has to make the decisions, there could be immense guilt or even emotional turmoil in making those difficult decisions at the end. This reminds me of a family that I have worked with, that there was 4 children involved. One was appointed as agent under the personal directive, and they made the ultimate decision to take mom off life support. And there was so much guilt associated with that. And so that's some of those non-technical, non-financial considerations you have to take when you're determining who best to appoint under your personal directive. Which brings me to the next point, is that if you have nobody in your network to appoint, let's say you don't have any close family members or friends, who do you appoint? And it really is a difficult role to fill. You cannot hire this job. You cannot find someone and pay the money to act under the personal directive. So if you absolutely have nobody in your network, as a last resort, you could potentially approach the public guardian and trustee's office and see what their thoughts are in accepting the appointment. And I know you and I were chatting before this recording, Gord, is that in your experience, you found it very difficult for them to agree to take on the appointment. They always seek out alternate options before they will help someone, because really it should be a family or friend matter. But that is an avenue that clients can explore if they're looking to fill that role.
Yeah, and I think it's better not to appoint a family member or maybe an extended family member, right, who best would be a little more dispassionate about the decision. So in the example you give of 4 children, and do you pick one or do you appoint all 4? That may be cumbersome and lead to indecision, and which may not be in the person's best interest. Maybe if you got your best friend or somebody who knows you well and knows what you would want and can help mediate decision making. It's not one kid having authority over versus others don't. So sometimes just somebody. It could be a non-family member. Unfortunately, you can't go to trust companies. They won't do this work. They won't take those appointments because they only deal with the financial matter. Trust company appointments in the past. So if you're thinking that might be an option because we've talked about it on previous episodes, then unfortunately it's not in this case. Yeah, the government is the guardian of last resort, if you will. If there's nobody, they can be appointed. They have such a workload and they're understaffed that if there's anybody else who's prepared to serve in that role, they will defer always to the family. unless there's an actual problem and there's abuse going on. And sometimes in those roles, they'll step in, or they're mandated by the court to step in. But if generally speaking, they go, we'll never agree to it at the time. But if they're faced with a situation, they may be taking on that appointment or agree to it ahead of time or be ordered by the court to do it. But it's just really tough to get their consent ahead of time. In the foreseeable future, you need to work on building those relationships so you can nurture the relationships, get comfortable with somebody who's close to you who might be able to do that, right? And serve in those roles. So sometimes there isn't an obvious answer, but something to work on. But it's really tough. This is what a lot of people struggle with. Who do I want to leave this to? As we wrap up, I just want to thank our audience for listening in. An interesting conversation regarding decision making. And I think the importance of having the personal directive. While from an estate perspective, the personal directive stops having any effect as of the date of death, it's important as part of the planning process and for our listeners, a good opportunity to look at the personal directive and say, is mine still current? Or if I don't have one, I best have one in place. And then you can share with your family or the loved ones or the people who you appoint, what would your wishes be, right? What's the level of care you would want? And what does that look like? So I think an important topic. Thank you all for listening in on that. If you have any questions, feel free to reach out to us. In order for us to get this message out to more people, it helps if you subscribe. So we encourage you to do that both on the podcast or in our YouTube channel. Share those episodes. If you listen to this and go, this could be really helpful for somebody, then it does us great joy to know that this information can be shared amongst other people. So feel free to do that. And of course, if you need help with any of it, we're happy to guide people through a deeper review and or understanding of matters relating to the personal directives. But with that, we'll wrap up for another episode of Estates Made Simple. And thank you for this opportunity, Jenna, and good conversation.
Thank you.